I would like to introduce our presenter for this afternoon, Barbara Berschler. Did I pronounce that correctly, Barbara?
Yes, thank you.
Great. Has since 1985 advised business owners throughout the Maryland, Washington, D.C. metropolitan area, as well as international clients. Ms. Berschler's practice consists of general business and commercial law, with a special focus on intellectual property law, copyrights, and trademarks. She has earned both a JD Juris Doctor and an LLM Master of Laws degrees. She was awarded the Brinks, Hoffer, Gilson, and Lyle Award for Excellence in Intellectual Property Law. So needless to say, this presenter this afternoon knows what she's talking about. So Barbara, let's start.
Thank you very much, Janine. I appreciate the introduction. Now, overarching question is, you always want to ask yourself or whoever you're working with, who owns the intellectual property? Let's get started. And the beginning is, well, what is copyright? From the slide, it speaks that there are exclusive rights that the law grants to the creator, also known as the author. You might also hear the owner of the copyright, but it's for a limited period of time. So once the time expires, then whatever that work is, it's in the public domain, and the author no longer is able to restrict usage. Now, what are those exclusive rights? Well, it's the right to reproduce or to copy whatever the work is, to make derivative works. And a derivative work is based on the original. So as an example, if somebody wrote a novel, they would be able to permit somebody else to base a play on that novel. The play would be the derivative work. Another right is to be able to distribute it. You send it out, you give it away, you charge for it. And then some of the activities are perform, display, and transmit. So that's covering what are the exclusive rights that as the copyright owner you would have. Next slide. We know there's exclusive rights, but how do you get the rights? And that's how are rights in copyright created and protected. So in the United States, these copyright rights that we've talked about, they automatically attach. You automatically get them once you've fixed the work in a tangible medium of expression and provided that the work meets certain minimum standards. So again, it automatically attaches. It doesn't require you to do anything special, although we'll talk about what things you can do. And it has to be in a fixed medium. It can't just be in your head. It can't just be an idea. Now, if we look at, well, what kind of works can be protected by copyright? And here we have the list that's out of the statute, and the major one of literary works. So plays, books, comic books even, but that includes software. So even though we can't read the code, that doesn't mean that it's not protected. The code author of the code is not protected by copyright. Musical works, dramatic works, pictorial and graphic works. And an example of that is like a website. And so the look and the feel that you get from your web pages. Motion pictures and sound recordings. Next slide. Now, to reiterate, what is protected by copyright, those exclusive rights, is the expression of the idea, not the idea itself. And what I mean by that is, or an example would be, if you were going to draw a tree and I was standing next to you and I draw the same tree, but we're both looking at the tree, clearly our trees, our drawings are going to look similar. But in that instance, I didn't copy from you and you didn't copy from me. So that's how it is that it's original to the author, and it's not merely an idea, but there's something that's fixed. Plus, there's a low level of creativity that's required. So you wouldn't just have an alphabetical list of something and claim copyright in that. Next slide, please. So we now know, well, what is protected by copyright? So what does copyright not cover? And it's ideas, procedures, systems, methods, etc. Those kinds of activities or intellectual property, to protect it, you'd need to look to patents, which we're going to talk a little bit about, and trade secrets. They're not that kind of, the ideas and the procedures are not the subject of, for available under copyright protection. And then works that are in the public domain. And so, for example, as we said, the copyright is for a limited period of time. Once that time expires, then the work is in the public domain. The term of copyright has expanded considerably. And so in the case of an individual, it's going to be the life of that individual plus 70 years. So once the person passes away, there will still be rights in the copyright that are inherited by someone. And therefore, if you've got anything really great, you probably should attend to it in your will. Aside from individuals, if the entity, if an employer, for instance, is considered the author, then it's going to be 95 years from publication. Next slide. We say that it's an author, a creator, and clearly that if you're in the create something original, artistic, even doodles, or even the notes you might be taking as we're progressing through this webinar, immediately copyright has attached because you fixed them in a way that other people can see them. So you would think possibly an employee, they're the creator of a memo, of whatever a particular work is. But no, in that circumstance, what the employee has done is considered a work made for hire. And so from the get-go, the employer owns it. Now, this term of a work made for hire is not just limited to working with employees or the work created by employees, but it can be if you're contracting with a third party to create something for you. And if that work comes within a category, so for instance, an important one would be films, it could be like a motion picture, it could be a collective work where somebody pulls together a bunch of short stories. So in those instances, provided the person who originally created the work agreed in a writing that the work was a work made for hire, then whoever is paying for that work ends up with the ownership of the copyright. Now, if the independent contractor's work is not within these stated categories, then you need to, at the time of contracting with that contractor, have an agreement in place that says that they are assigning their rights to you, to the employer, whoever is paying for that work. So an example would be an artist is painting a picture and you buy the picture, but that doesn't mean you have purchased the copyright in the picture. What you've done is you now own the physical item, but you do not have those exclusive rights to make copies of it, to display it in the public, and so forth. So that's why if you are interested and need to have the copyright, then you need to have a writing. And finally, by inheritance, which we said for the life of the author plus 70 years, there's going to be a long time, conceivably, that the copyright exists.